Thank you. So Amy, I know, is known to lots of you, and I'm sort of piggybacking on her expertise here, but we're really happy to be here today to share some of the work that we're doing from our home here in Ottawa, Ontario, Canada, on judicial analytics. So the first thing I'll start with is the most obvious question, which is sort of what do we mean when we talk about judicial analytics? And a brief definition that will suffice for our purposes today is the idea that judicial analytics means using technology to analyze digital court data in order to detect and convey observable patterns. So to take a really simple example, a judicial analytics tool might, for example, amalgamate and analyze all of the decisions that an appeal judge participated in during their tenure on the bench, let's say, and determine the percentage of times that that judge has been in the dissent versus the majority. Academics have certainly done this kind of empirical work for a long time, but of course, our current technological reality allows for something new. And that something new is that with analytics technologies, we can do these kind of empirical analyses of courts in a fraction of the time, and people who don't necessarily have deep technical or methodological training can conduct these kinds of analyses. Now, we sort of became interested in this topic around 2019 after reports that the French government had passed a new law that essentially banned the public from analyzing information in publicly available court decisions in order to draw insights about the judicial behavior of individual judges. We were interested in this French law, not least because it seemed from our perspective like a very strong stance against public engagement with court data. And it led us to start thinking about this topic, both generally and in the Canadian context specifically. In particular, we were then, and we continue to be, interested in the normative questions that underpin judicial analytics. So as opposed to the technological questions about what these tools can do, how they might make predictions about a certain judge's behavior in a certain kind of case, we're sort of interested in the normative questions that underpin some of those uses. In particular, we have sort of two big issues that have motivated our work in this area. The first is, as we enter a world with more digital data about courts, with more increasingly powerful technological tools that can extract and analyze data and reveal trends and tendencies about courts and judges, what are the benefits and risks of this new sort of frontier, this new world? And second, as analytics make it easier to glean information about courts and judges, what are the conditions for these sort of ethical and effective production of and consumption of judicial analytics output? So how should we be engaging with this kind of data? So we've published 3 articles now looking at various dimensions of these questions, and we thought today we'd just share some of our sort of key insights from that work with you. So with that sort of set up, I'm going to turn it over to Amy to talk a little bit about the benefits and the risks.
Thanks, Jena. So first, to talk about the issue of benefits. We looked at this in some of our work through thinking about benefits for the public and also judges and courts. And so what are some of the benefits for the public? Canada, like your jurisdiction in the United States and other common law jurisdictions, do pride themselves on having open court processes. People can attend court, judicial decisions are generally published. And in many important respects, that kind of openness does create meaningful transparency about the system, but it hasn't necessarily resulted in widespread or sophisticated understanding about judges and judicial behavior. If you think about it, the public, at least in Canada, has far more insight into the behavior of professional athletes in a given year than a judge. And so judicial analytics tools do hold the potential to give the public increased insight to the work of courts. And the idea is, with this increased information, insight, the public can then more effectively participate, also critique the work of courts. Also consider the benefits to judges and courts themselves. Judicial analytics tools can give judges insights about themselves, about patterns in their work they might otherwise be unaware of. And in theory, that could be used to potentially reform practices if that is seen to be necessary. There's some examples of this already happening a bit. A really simple and maybe interesting example is after some empirical work on the US Supreme Court in response to a study that showed female justices were interrupted by both male justices and male lawyers at a disproportionate rate. The Supreme Court actually changed the rules of oral argument to allow each justice to answer questions individually after each lawyer's submissions were complete, sort of making for a more equal playing field. And so just a simple example about how more data can also help courts improve what they do. Alongside those benefits, there are, of course, risks in the rise of analytics-generated information about courts and judges. One category is a concern about the potential for poor quality tools. And so, to date, we've had some generally big and responsible players in this area. But as these tools get cheaper and easier to create, will we have an ecosystem flooded with subpar tools that generate bad information? And that can do actually quite a bit of harm to the public, of course. Relatedly, there's a concern, or we have a concern about increased what we call data in the air, where people are just producing numbers about statistics about what judges are doing, about what courts are doing, just because they can. And maybe without a sense about why that empirical information is important, or without articulating or thinking about what benchmarks that information should be weighed against. And we certainly have seen some of this already happening in the academic realm and the commercial realm as well. To give a simple example, we use one of our papers, take an output that's published on social media or in an academic paper that says, Supreme Court of Canada decisions are 15% longer than they were 5 years ago. Is that good or bad? What's the point of putting that number out there without an account of the relationship between the length of a judgment and judgment writing? And so without a benchmark or actually even a theory of what makes judicial writing good or bad, it's challenging to make meaning out of statistics. Second, we raise a question about what can or should be measured. Some data points are pretty uncontroversial, how long a decision is, how long an oral hearing takes. But more of the time, the most interesting information about courts is that which seems to be revelatory of the more human inner workings of the institution and judges. And in those cases, measurement choices are going to be a lot more subjective and a lot more contested. You can think about studies, for example, that try and rank judges as to who's the most liberal, who's the most feminist, using quantitative data. And so if the academics or the public are going to digest this data, it's really important to be transparent and have a lot of clarity about how these concepts are being measured, what data points are going into them, how those data points are weighed, how they were chosen. And maybe also some restraint needs to go into deciding what can be meaningfully measured. Some concepts are just perhaps immeasurable or unquantifiable. Who's the fairest judge? Who's the most just judge could be an example. A final thing in terms of these risks I'll highlight from our writing is the potential of people seeing analytics outputs and moving too quickly to causal conclusions. As with life, there's often kind of multiple reasons why something may happen. Sometimes contradictory reasons could be identified, but it can be really seductive to try and tell a tidy causal story. And that may make for more flashy research, but those connections may be a lot more illusory if you get behind it. Just wrapping up here in our last minute or so, this brings us to our most recent paper when we ask, how might we respond to the risks of judicial analytics in a meaningful way while still leveraging the benefits of this technology? And we identified 2 types of literacy that are key for both data producers, so those creating judicial analytics tools, and also data consumers, those receiving or relying on analytics generated information. So first, data statistical literacy. That means anyone engaged with analytics information needs to understand something about data and statistics so they can critically engage with statistics about judges. So, what's the sample size? How's that relevant? Is this a statistically relevant difference that we're seeing in the numbers? and also avoid the pitfalls of assuming causality, because I think we do see that coming to the fore quite often. Second, domain literacy. Those engaged with analytics, again, both on the production and the consumption side, need to have sufficient information about the court, both its institutional character, procedural, substantive parts of its work, to interpret data in the right context. So someone without the requisite domain literacy, for example, might assume that a judge who dissents more often or who is appealed for more often is necessarily inherently a bad judge. But someone who may know more about the judicial system may understand, some appeals may be automatic as of right. Writing a dissent doesn't necessarily mean that you are kind of a bad judge and don't have the right qualities to be a judge. So accurate and fully contextualized information, should be at the forefront of the movement to apply judicial analytics to court data, and that's something we're trying to contribute to the conversation in this area. And that takes us to our thank yous. Thank you for hosting us, and we welcome any questions either now or via email. Thank you.